Well, people can judge for themselves. We've conducted a hearing to testify.
It's not a hearing, it's a witch hunt.
Hang on. No.
There was no.
Closing argument. All right. Any further outbursts? You'll have to leave or you'll be taken into custody.
So practicing law, none of you have an actual license to practice law. Did you know that, right? A bar association membership is not a license. You're not registered on LARA, the state's licensing administration. You're not registered. Your primary oath is to the bar association. And we know about your secret commitments to one another and not to follow the unalienable rights of the people. So if your court finds me guilty, your court is finding every God-given right the universe has ever known to be a fraud.
So Ms. Richmond, if you want to come forward to the table.
I'm unable to do that. I don't have a license to practice law in the bar arena and in the water. I am a woman on the land, under the law of the land, and under the one true God. I'm a living soul. And
okay,
you're offered a contract with Beth Michelle Bridgman in all caps. I'm not that person. Anybody else in this room that person?
Hey, hang on.
Okay.
So, Ms. Bridgman, you're correct that the bar in the courtroom, people have to be licensed attorneys to cross the bar to represent other people. Of course, people can and do, as you have represented yourself on this side of the bar. So you're welcome to sit at the table there, which would perhaps be more comfortable for you. If you would prefer to proceed from where you're standing or sitting, that's fine with me as well. Do you have a preference then?
I'd like to stay right here.
Okay,
My honor. I think the first matter I need to address is that I have a copy of your sworn oath here, and
that's not relevant for today. So, Ms. Richmond, you filed a motion for me to recuse myself. I'm going to deny that motion. It didn't present any basis for recusal, so that motion is denied. And we're here for a contempt hearing, which you've been rained on for your contempt for interfering in the court process and unauthorized practice of law, and then failing to attend. Okay, Ms. Richmond, now's the time you can make your opening statement to me, but first, do you wish to have some witnesses that be presented sequestered, meaning that they have to leave the courtroom and be instructed?
I am not even contracted with this hearing, this administrative hearing. I cannot be adulterous to my own oath of office.
I'm going to assume that you're
put myself under an authority.
Sequestration orders and no sequestration orders. So go ahead with your opening statement.
Law is must be a contract. In the absence of a valid contract, there is no law, period, which might be part of the problem that we have here. Now,
I don't mean to interrupt you, and I'm not going to interrupt you often during your opening statement. I do want you to know that because of the way the video feed works, from where you're standing, it's not picking you up. And I assume that the audio is going to work through for the district courtroom that's clipping it. But
I'm content with all the people that are here that reside on the land that most of us call Michigan. If that's who is bringing charges against me and there is no person injured, there's no property damage, there should be no case. So my statement is that how can I put myself in your jurisdiction, except that you could do it by force and arrest me with 4 deputies with no due process and violate my unalienable rights to try to force me into your jurisdiction, because your oath of office is a violation of Section 5, United States Code 3001. You do not have an oath giver. You have yourself that signed it, and you have a notary. I just did an oath with the people here today, and they signed it, I signed it, and we got a couple of them notarized. That's how it should be. This is not a valid oath. I cannot stand in this court and be brought up because, in fact, you are operating or masquerading as a lawful court, but you're in fraud of the very oath that would give your court legitimacy. I have a remedy, Your Honor. I have an oath here. And if you would like to take it in the presence of the people and sign and notarize, we can move forward. Otherwise, I would be violating my very own oath of office and an oath I just took downstairs as well. To the United States of America's Constitution. Well, it concludes the fact that I see that you're not interested or care what the people and the truth of the lawful process of the people. I don't know if anybody else cares to say that. There's no injury and there's no property damage. I do believe I withheld Mr. Gilbert from some money he was probably banking on that day. And I believe the court operates in commerce and is here to make a profit on all of their activities. So that is my violation. The state of Michigan hated that I blocked an attorney before Seth was arraigned. You cannot be bringing me in the hallway downstairs and charging me, and then tell me that you're the true judge of the 53rd Circuit Court when your oath is not properly even administered. I happen to know, I believe, did you take a bar association oath?
I'm not answering questions. Are you done with your opening statement?
I guess I don't really need to be here because this is not a legitimate court that I should be standing in, and I will not violate my own oath by submitting myself to an authority that has not done the proper oath himself.
All right, Ms. Miller, your first witness.
Thank you, Your Honor. Before call.
Ms. Richmond, you may not leave the courtroom.
I know you have people that need to know that they are violating people's unalienable rights by picking them off the street without a single piece of paperwork.
Okay, Ms. Miller, who's your first witness?
Does anybody else have a problem with this?
All right, hang on. There's going to be no outbursts in the courtroom, or you'll have to be removed. All right, Mr. Bird, please raise your right hand. You cannot leave the courtroom. You swear to tell the truth, the whole truth, and nothing but the truth, so that? Yes. Okay.
I'd be happy to administer a
Ms.
legitimate oath.
Richmond, hang on. So the court process works. I gave you both a chance for your opening statements.
This is not a
Hold on,
court
hold on.
I can submit to.
Hold on. The process is going to be.
I know you like to look really regal up there and
You know,
maintain a degree of authority,
Ms.
and you have
Richmond.
guys carrying guns.
Ms. Richmond,
I'm fully aware of that.
Ms.
Where are
Richmond,
their
I
body
can-
cams and their vehicle
I'm
cams?
just putting you in the jail cell. You can watch it from there.
I know that's what you're hoping to do.
So Ms. Miller is going to be given an opportunity to question the witness, and then you'll be given an opportunity to question the witnesses. That's how court procedure operates. If you interfere with that procedure, you're going to be in direct contempt of court. Ms. Miller, proceed with your question.
I would have to be. I know how to calm kids down, and was I not willing to stand with you if you were going to be pulled over? Did I not tell you if Dukowski came at you for the 4th time to get a hold of me?
Yeah, I felt more confident after that, but I'm still nervous when cops pull me over, even when I'm not in the wrong.
Is it possible because of your high anxiety around and this, you're not alone in this, dude. I can show you a dozen people in this room at least who have high anxiety around this place and anything having to do with it. And these gentlemen, is it possible that some of your memory today is not exactly right?
Maybe not 100%.
Do you think I felt I needed to protect you with Gilbert? Because I knew what Gilbert was trying to do. He was trying to put you back in their jurisdiction. They were trying to make money off of you. And I was preventing that, right?
I felt guided almost.
You felt what?
I felt guided almost because nobody was really telling me what to do.
So there were a few details that I would say I recollect differently, but I would no more put any of my friends in the jurisdiction of his authority and this court's authority and subpoenas and bonds and everything else to testify against you.
Okay, that's not the
Because
question.
I don't
Ask me
care,
a
Your
question.
Honor. I'm here to protect Seth
All right.
and anybody else.
Can you redirect?
Any questions, Mr. Gilbert?
Ms. Richmond, any cross-exam questions for Mr. Gilbert?
Yes. So you take a kid who's anxious, gave away all of his inalienable rights when if he gave his driver's license, Dukowski just violated the law. He was a passenger in the vehicle. And he didn't give accurate testimony, but I'm not going to make him perjure himself. And everything you just said does not line up with people that I have here that were there. Do you want me to call witnesses, Your Honor?
Okay, you haven't asked the witness a question.
Okay.
So I'm going to assume you don't want to ask the witness a question. Okay.
Was Seth really in the courtroom and arraigned and approached by you in the courtroom?
He was never arraigned. He was in the courtroom, and the judge advised that he needed to speak with him. And I said I had 2 more matters. I'd be out in the hallway, and that's where you and him were waiting out in the hallway. That's when I tried to approach Mr. Clark.
Did Seth and I, were we aware that the judge, because was it perhaps that when Seth turned in the paperwork to the clerk of court, that she let the judge know and the judge let you know, go out there and get him, and she's talking to him, and you better go get him arraigned? You better go talk to him? Because I already had him out there and done before you were ever on the scene. You took all of his inalienable rights, violated due process for the kid, and then you're trying to make him put him in your jurisdiction, and I was saving him from that because.
Do you have a question for Mr. Gilbert?
Yes.
Ask it.
Are you prepared to perjure yourself? Okay, it's nice that, I'm glad I didn't.
That's not a proper question. I'm going to determine that Ms. Richmond is elected that she doesn't want to ask.
Okay,
Mr. Gilbert
let me ask
question.
him.
She just wants to rail against him. Mr. Gilbert, you can step down.
Yeah, how do you ask questions of when you've all cooked this all up between yourselves?
Ms. Miller, your next witness.
Your Honor, I don't have any further witnesses in this matter.
Okay. And the court will take judicial notice of its own files and the transcript of the arraignment on November 30th, the transcript of the order to show cause on December 21st, and on the failure to appear. The court will take judicial notice of Ms. Richmond's returning the order to show up, the order to appear, cut into strips with the writing the offer to contract is not accepted, as well as the statements that she made at her arraignment on the bench warrant. All right, so Ms. Richmond,
this is
do
how
you
you
have
can-
any? Do you have any witnesses that you wish to present?
I have to say that even being here today and putting myself and submitting myself to your authority that has not been substantiated goes against the one and living God that I respond to. You cannot. ask
Okay,
me
so
to
I've
do that.
given
Does
you an
anybody
opportunity.
want to go stand on what happened that day? But I don't want anybody to enter your jurisdiction, Your
Okay,
Honor,
so-
because,
So you're not
okay,
calling.
my honor, let's do it this way.
Hang on. So so I've offered you an opportunity to call witnesses and you've elected not to. Closing arguments, Ms. Miller.
Your Honor, I ask that the court find Ms. Bridgman in contempt for the unauthorized, for interfering with Mr. Flores' arraignment from the MIDC and engaging in unauthorized practice of law. There was testimony that Mr. Flores didn't know Ms. Bridgman before he entered the courtroom or the courthouse on the 30th, that she approached him, that she was with him when she was with him in the courtroom. She told him that he didn't need a lawyer. She was providing legal advice to him, saying that he didn't need to, he was driving his personal vehicle and he didn't need to engage with the process. He testified that she told him what to write on the ticket to provide to the court. I asked the court to take judicial notice of the ticket with Mr. Flores' writing on it. He testified that once he turned it in, he was advised to leave the building by Ms. Bridgman before he had his arraignment. So I would, and then further the testimony of Mr. Gilbert, that he was the arraignment attorney, that he was in the courtroom when the judge indicated that Mr. Flores should meet with him. He testified that Ms. Bridgman interrupted him 3 times from a meeting with Mr. Flores that he tried to but wasn't able to. He wasn't able to advise him of his rights or to go over the ticket with him, and further that Mr. Flores left without being arraigned on the matter.
Is it still possible to object to all these presumptive evidences? You brought your own people in who are on the county payroll.
It's closing argument. Go ahead. You
And I would
have your
ask-
chance.
And I would ask the court, I think it's clear that Ms. Bridgman was interfering with Mr. Flores' meeting with the arraignment attorney by physically preventing Mr. Gilbert from meeting with him, further telling him what to put on a piece of a document to submit to the court on his behalf. That would also be engaging in giving him legal advice. So I find I'd ask the court to find her contempt on that. And I'd also ask the court to find her contempt for failing to appear on the show cause that was issued to her on the 20th of December. Thank you.
All right, thank you. Ms. Bridgman, now's your opportunity to make any closing argument that you wish. Go ahead.
I am not in this hearing situation. This has been conducted as what is called a star chamber. As all of our founding fathers left because the Bar Association members are arraigned against a witness and they have no due process. Has anybody here not witnessed a breach of public trust and due process?
Yes.
Well, people can judge for themselves. We've conducted a hearing to testify.
It's not a hearing, it's a witch hunt.
Hang on. Okay.
There was no.
Conclude your closing argument. All right. Any further outbursts? You'll have to leave or you'll be taken into custody.
So,
This in order.
Practicing law, none of you have an actual license to practice law. Did you know that, right? A Bar Association membership is not a license. You're not registered on LARA, the state's licensing administration. You're not registered. Your primary oath is to the Bar Association. We know about your secret commitments to one another and not to follow the unalienable rights of the people and due process.
It's the people's court.
This is not, you have just set up a star chamber and you've got guys with guns ready to carry out whatever you want, and you have not even taken enough care about the people and your situation in the court to execute a proper oath. You should have had somebody swear that oath to you. You can't sign your own oath and have it notarized. You did that with the prosecutor. You had to have somebody who swore you in, signing it, and then a notary. It takes 3 people. I should not be submitted. If somebody is practicing law without a license, it's all of you Bar Association members.
Yep.
No, there is no license. It's a private membership. And I cannot subject myself as a living soul to an authority that violates my God-given unalienable rights. And if you gentlemen carry that out, have you any idea what you're doing, what you're being asked to do? You need to think about it, because I can tell you right now, our military is watching every move you make right now. This is your opportunity to stand for the people and not for the people that are trying to steal every one of our rights as they did with Seth Flores. You should be ashamed of yourself, Deputy Dukowski. You told him on the second, and like Pete, you were gonna take his vehicle and he was gonna have to pay $12,000 to get it out of impound. Do you know how many friends I have that can't drive a freaking car in this county up until the age of 35? I don't practice law. I practice rights. I practice people living free and supporting one another. So if your court finds me guilty, your court is finding every God-given right the universe has ever known to be a fraud. We would be happy to administer the real oath for you today, Judge Gothia. We have a body of people. We would be happy to do that. We need a district court judge for the people to reinstate common law. The Bar Association has bought out the entire state of Michigan for the CCP. I know what that means. I know what your role in that means. And I believe redemption is for everyone. And I could be your best friend to make, I believe you know God's truth. I believe you want to do God's truth. And I believe you could be the man that we need. But we have to leave this process of the Bar Association, and you have to take an accurate oath.
I'll witness it.
Oh, there's a two out there.
All right, thank you, Ms. Bridger. And now I'll make the ruling. Article 6 of Michigan's Constitution of 1963 vests the judicial power of the state of Michigan in the Supreme Court and courts of record as established by law. It also gives the Supreme Court superintending control over all the lower courts. Michigan's Constitution also provides for the passage of public acts passed by the legislature and approved by the governor. These statutes, despite bad information that people get online, have the force of law. Michigan has a statutory system regulating the practice of law. Michigan compiled law 600.901 through 949. Section 904 vests the Supreme Court with the power over the state. Ms. Richmond, you may not leave the courtroom.
I'm going to talk to somebody. I'm not trying to get away, Dukowski. You won't see me at 3
Ms.
a.m. on
Richmond.
Butler Road.
I'm giving my ruling here.
Okay.
Section 904 vests the Supreme Court with power over the State Bar of Michigan, which under Section 901 is a public body corporate consisting of all persons licensed to practice law in Michigan. Section 916 makes it illegal for anyone to practice law unless they're licensed to do so.
You're not
The Michigan
licensed.
Supreme Court in State Bar v. Kramer, 399 Mich. 116 in 1976, noted that this statutory scheme merely recognizes the inherent authority of the courts at common law to control the practice of law, dating back to the common law of England. When so-called sovereign citizens complain about the common law, they neglect to notice that the common law was what courts said.
Codes and
This
statutes
regulation is
are not
rooted in the
law.
importance of protecting the public from the danger of unskilled persons practicing law.
Oh my goodness.
What constitutes the practice of law? In Dressel v. Ameribank, the Michigan Supreme Court in 2003 held that a person engages in the practice of law when he counsels or assists another in matters that require the use of legal discretion and profound legal knowledge.
So, Your Honor, where
Now,
was
basic
that
free
in my
speech
latest
protection
charges,
Protect the right of people to espouse beliefs and to tell other people about those beliefs.
Ryan?
So Ms. Bridgman has the free speech right to believe what she wants to about courts and government and to tell other people about that. This includes, of course, criticism of government and of the courts, but to give advice, guidance, and assistance to another person in their own legal matter at the courthouse to be applied to their particular case at that time crosses the line into the practice of law. At its heart, the practice of law is applying legal knowledge to a particular issue or problem. This unauthorized practice of law is a contempt of court.
You had that written up earlier, didn't you?
Additionally, interfering with someone meeting with their attorney is a disruption of the court process and is therefore also a contempt of court.
He was not there
The
to meet
primary
his
purpose of
attorney
the
yet.
contempt power is to preserve the effectiveness and sustain the power of the court. The power to hold a party in contempt is an important judiciary, yet still the legislature has recognized this and codified it. This is merely a recognition of the common law contempt power of courts. Among these statutes, Section 600, Section 1701H provides that any court of record may hold in contempt all persons for assuming to be and acting as officers, attorneys, or counselors of any court without
Oh,
authority,
good Lord.
or for other unlawful interference with or resistance to the process or proceedings in any action. So interfering with a person's consultation with an appointed attorney is directed by a judge, interferes with that process in that court case, and is a contempt of court.
But they tell
Let's
you
just
that.
pretend.
But there are two forms of contempt, civil and criminal. Civil contempt applies when someone refuses to obey a court order and the court coerces their compliance. So in civil contempt, the person can contempt by obeying the order. Criminal contempt
You
applies
guys
to
put
past
hands on
action
me today.
for failure to appear as a criminal contempt.
Be careful.
The court, Ms. Bridgman, you've had your, I've given you every
Darren, you are
opportunity.
misbehaving. You had this prepared. You
I
looked it
am.
up with your witnesses. Come on
The
now.
Court of Appeals has specifically.
I was not
held
practicing
criminal
law.
contempt
I was practicing rights. Common law and the Constitution is about rights, not law,
And so the court
not your legal
finds
stuff.
Ms. Bridgman in contempt of court
Oh, yes.
for the unauthorized practice of law in giving Mr. Flores advice particular to his situation on what to write on his ticket as a lawful defense, to disobey the court's direction to consult with the MITC attorney, which is required by law, and to leave the
By codes and
courthouse. He was
statutes.
not authorized to do so. And that resulted in harm to Mr. Flores. He was in jeopardy of contempt of court by leaving without finishing the arraignment process by
My
following
honor.
the bad advice of Ms. Bridgman.
I am
That
not
was a
wanting to be in
court by
contempt of court.
practicing law. It's a contempt of court for interfering with the court process. Ms. Bridgman is also in contempt of court for failing to appear for the show cause hearing when she didn't show up for it, but she instead beforehand turned in the order, cut up into little pieces with a statement, your offer to contract is not accepted.
You trespassed on my yard with
Courts have
no,
the inherent authority to
right.
compel attendance, and she is in contempt of court for doing that. So Ms. Bridgman is in contempt of court for unauthorized practice of law and for the interfering with the court process on November 30th, 2023. She's also in contempt of court for failing to appear
oh, the
for her
council.
show cause
I don't
hearing
need. Better be careful. I know some jujitsu.
on what day was that scheduled for?
Oh, I remember.
On December 20, I'm sorry.
So, my honor.
So she's in contempt of court for failing to appear on December 20th. All right, Ms. Bridgman, do you have anything you wish to say before the court pronounces sentence for the contempt?
Under common law, which is the only true law because comes from God's natural law, and the Constitution is based on that. The Constitution is not about law, it's about rights. I was not talking to Mr. Flores about any legal thing because I'm not a bar association lawyer. I don't know about all your laws. I do know that the need to have a attorney at arraignment, from what State Trooper Brenda Casperson told me, only started a year ago. That is codes and statutes. We are not bound by that. We are living beings. We are not the corporate dead entity of the court system. I did not practice law. I practiced his rights. Do you know there are plenty of other counties in this state that accept that same documentation that I filed and had Seth filed? I was hoping to make him unafraid of all of these. He has good things to say about a couple of your deputies. They're not all like that. This court is for profit. So standing in the way of that attorney, but that testimony, Mr. Gilbert, you should be ashamed of yourself, was not truthful. You had never approached.
All right, Ms. Bridgman, this is your opportunity to tell me what penalty I should give you, if any.
Was anybody harmed? Was there any other financial damage to Seth Flores? I know there was to Mr. Gilbert because he lost a client that day, but then he recovered that. Good. Okay. Are we not allowed to talk to people in the courthouse, not in the courtroom? Is that not a public space? Are we not allowed to help a fellow citizen understand that he doesn't have to lose everything in his life because he's just getting started? That he can have people stand with him and encourage him and coach him through, maybe handle his drinking. I suggested that he stop drinking and he start to, pay attention, and we'll be there if he gets pulled over because he's afraid. I don't see where there has been any harm. And if you can rule that is contempt, I have no longer I see no ability to redeem anything in this courtroom. You refuse to address your oath. And if you hold me in contempt of court, I think that's quite unbelievable.
All right, well, I've already
Yeah,
so.
I do have somebody who would like to make a statement on my behalf.
No, that's not allowed. All right, so I have
See,
filed.
you're
a-
judge,
I-
jury.
yeah, you've made all your statements. I have filed an oath proper under the laws. I filed a constitutional oath required by Article 1, Section 11 of the state constitution. All these sovereign citizen folks who get these crazy arguments online that are frankly just wrong, I encourage you, read the state constitution. You'll find that all this stuff you're getting from seminars or whatever online is just false. And Mr. Flores, to his harm, listened to it and almost got held in contempt. Ms. Bridgman has total disregard for the court's
He
authority.
testified. He was not harmed.
Courts are the way that citizens have recourse to the law. In societies that don't have a court system, they don't have the rule of law. You end up with the rule of
Okay.
bullying. And the court protects citizens from the government several times. There's important business to be had. There was important business to be had for Mr. Flores that day.
I don't think
And
the
Ms.
British.
Bridgman interfered.
Oh, wow.
But she totally refused to appear for court willfully. Her conduct today has been directly contumacious. And she has exhibited repeated disregard, and frankly, utter contempt for not only this court, but for really any court. And so.
Under the
any
Bar
process of law-
Association, I believe so. You're not
So-
upholding anything to the Constitution and
You know,
the state Constitution.
I do need to give a sentence that is proportionate, but also is enough to discourage Ms. Bridgman from this type of interference, and also to discourage other people from following down a similar path. So Ms. Bridgman, you're ordered a 30 days jail served forthwith.
That's fine.
Bethany, come with me, okay?
You know, guys, you need to arrest the judge for impersonating a public official. You need to arrest the judge for impersonating a public official. Okay, are you concerned at all about what you're being asked to do?
When does it have to be started? She can start with
Mr.
30 days
Flores,
anytime.
Mr. Flores said no harm was done to him.
You didn't say a date on when it should start. Can we talk about that?
Put me in public.
Does that start right this moment? Just let me go on before that. Work with it.
Okay. I need you to listen to the citizens of this community and understand that how are we ever going to get back a constitutional sheriff? You're not following anything about our inalienable rights. No, the military has a way to deal with it. I know. Oh, thanks for coming in, Lieutenant Tebow, because I mean, I only go into jail with 4 deputies. I mean, anything less would be an insult.
This is correct.
My daughter.
She follows the law, right?
All right, guys. We're just gonna let this stand. A man with a fraudulent oath of office. I can't wait to look into yours, Paige.
Keep going, please, thank
Yeah, I
you.
know.
Thank you.
You guys need to pick the right side.
Let's go.
Yes,
Yeah.
you
Pick
need
the
to
right
decide.
side.
Okay.
You are the people. We are.
Stop it, Zatowski. I know what I'm doing. Stop it. You got time.
No, it could be you next time.
Someday the right person will get
Your
it.
deputies have no right
Corruption.
to ask
You
a
guys don't have any
passenger
rights.
for their driver's license. That is illegal.
We need to put this over.
Someday somebody will take your rights away.
He's here. He's just lining up his people.
Are you going to tell your deputies that?
Man, we need to clear the courtroom.
Are you not answering this?
I will tell them whatever you want me to tell them.
They have no right to ask for a passenger's driver's
Okay,
license.
I'll tell her that.
It should be enforced.
Yes, sir.
Everybody's going.
Yes.
I want you to know I'm Joe Klein, okay? And I'm the lead man for the St. Clair County's within this county. I make several speeches on behalf of the United States, not only here in this county, but Pressfield and down in, Otsego. And my focus, yes, yeah. And my focus was to protect you guys from these red flag laws. I didn't want you guys going into the house at 3 o'clock, you know,